Maybe they left years ago. No calls, no support, no effort. And now suddenly they want parenting time? Is a parent who abandoned the family really allowed to come back and ask for visitation in Illinois? Well, I'm Jeff Hughes, lead attorney and CEO at Sterling Lawyers, and we work with families every week dealing with missing parents, sudden reappearances, and high conflict custody situations. In this video, I'll break down exactly how Illinois courts treat abandonment and what actually happens when an absent parent comes back asking for rights. Well, let's get into it. First, abandonment, that does not automatically end parenting rights. And this surprises many parents. Even if someone disappears for years, Illinois does not automatically cut off their rights, and you don't lose parental rights just by being absent, even if it feels wildly unfair. I recall a case once where we had a mom whose ex had not contacted their son in nearly 4 years. No birthday calls, no support, no messages, nothing. Then out of nowhere, he files for visitation. This mom came in terrified that the court would say, sure, here is your son back. But Illinois courts do not work like that. The judge did not give him automatic access, but they also did not dismiss him outright simply because he was gone. So here's where the next piece comes in. Number 2, the court focuses on best interest, not on punishment. In Illinois, the question is not, where have you been? The question is, will bringing this parent back into the child's life help or hurt the child? The judge will look at how long has that parent been gone? Why did the parent leave? And whether the child was harmed by their absence. Does the child know the parent? Is that parent stable now? And past issues such as abuse, substance use, criminal activity, and a whole host of things that fall into that category. Absent parents do not get a free pass, but the courts aren't in the business of punishing them either. They are in the business of protecting that child and doing what is in that child's best interest. And 3, the most common outcome in these situations is limited or supervised parenting time. When a parent has been gone for a significant period of time, Illinois courts almost never jump right into overnights with that parent. What the courts do is they typically order short daytime visits, supervised visitation centers, therapeutic reunification, gradual increases over many months, but no overnights until trust and safety are established. Another case once, we worked with a family where the biological father reappeared after a 5-year absence. He wanted alternating weekends immediately, a full schedule, and the judge shut that down real fast. What the judge did order was 2 hours, twice a month, in a supervised setting with a gradual review after 6 months. That child was protected. The reintroduction was safe and controlled, and the parent had to prove consistency before expanding their time with the child. And that is how Illinois handles checkbox reunions: slow, structured, and child-focused. Number 4, you can fight this parenting time request with the correct documentation. Illinois judges take abandonment very seriously, especially when that other parent ignored court orders, failed to pay child support, has a pattern of instability, and returns when it's convenient to them, not to the child, and when they have a history of abuse, neglect, or some other sort of criminal activity type behaviors. In these cases, you can always argue restricting parenting time for those reasons: supervised only access, mandatory therapy and counseling, or no visitation at all, especially if that time would endanger the child. In yet another case, we work with a parent who had not heard from her ex in 7 years. That is until she filed for child support, and suddenly, out of nowhere, he comes in wanting joint custody. And of course, the judge did not buy that, especially because our client had clear records of unpaid support, no communication, no involvement, and prior safety concerns. The court denied his request for overnight visitation entirely and ordered therapeutic supervision for future visits. His sudden interest did not override years of absence, especially because the evidence was rock solid. Documentation always matters. And number 5, termination of parental rights. That is a separate case altogether, and it is very rare in cases of abandonment. Often parents ask us, can I just terminate the rights? Well, Termination of parental rights in Illinois requires two significant steps. You have to prove that the parent is legally unfit, and yes, abandonment can qualify as that. But you also have to prove that termination is in the child's best interest. And that usually only happens when you have adoption cases or DCFS cases or extreme danger cases. Most cases do not qualify, and that is why managing a case like this is a real battle. So yes, a parent who abandons the family can show up and request visitation, but whether the court allows it and how much time they get depends entirely on what you do next. Many parents lose control early because they don't document the right things. They don't know what the judge is really looking for, and they don't follow the process that Illinois requires. In this next video, I'll show you the exact steps to win a custody case in Illinois, especially when the other parent is inconsistent, unstable, or suddenly reappearing. Let's walk through this together.